Describe the most significant type of vicarious liability recognized by tort law. And I gave you the hint being that it's in Latin.
Illegitimi non carborundum?
No. Respondeat superior.
That sounds like something out of Harry Potter, and I don't believe you.
Next
question.
Okay. Next question. Ermintrude sues Needlenose and Ludwig for negligence.
Not having horrible names.
Ermintrude's case goes to the jury, and the jury determines that Ermintrude suffered $10,000 in damages, but that all three parties failed to exercise reasonable care. The jury assesses Ludwig's fault at 50% of the total, Needlenose's fault at 15% of the total, and Ermintrude's fault at 35% of the total. If the jurisdiction has adopted a pure form of comparative negligence, but has not abolished the common law rule concerning joint and several liability, which of the following statements is correct?
I'm strapped in, yes.
Okay. A. Ermintrude will receive a judgment for $6,500 against both Ludwig and Needlenose, and may choose to recover all or part of that sum from either or both defendant. Ermintrude will receive a judgment, this is B. Ermintrude will receive a judgment for $5,000 against Ludwig and $1,500 against Needlenose. Ermintrude will receive a judgment of $10,000 against both Ludwig and Needlenose, and may choose to recover all or part of that sum from either or both defendants. Or answer D. Ermintrude will receive a judgment of $5,000 against Ludwig, but nothing against Needlenose because her negligence exceeded his.
I was told the answer was always C.
Incorrect.
Can I sue the person that told me that for providing negligent advice they knew to be false in certain situations?
No.
No? Okay.
Okay. All right, this question's easier to do. I think you'll appreciate this. You ready? Question 3. Bender picked up Fry on the way to the park, where they planned to play basketball. Excited about the game, Bender lost concentration on his driving and collided with a car driven by Hermes, who had stopped at a red light. Hermes sues Bender and Fry concerning Fry's liability. Which of the following statements is accurate? A. Unless Hermes can demonstrate that Fry acted negligently in some manner, Fry cannot be held liable.
Was Fry driving? No, okay.
Good, that's the key to this question. B. Because Bender and Fry were involved in a joint venture, Fry can be held vicariously liable for Bender's negligence. If Fry was aware that Bender was a bad driver, Fry can be held liable to Hermes. Or D. Because the danger associated with careless driving outweighs any benefit to be obtained from the basketball game, Fry and Bender can both be held liable to Hermes, an innocent victim.
A.
Correct.
Yay, I get 1 legal point.
Okay, question 4.
Yeah.
Which of the following assertions is least relevant to the debate over whether to abolish joint and several liability? A. Joint and several liability is inconsistent with the modern adoption of comparative fault. B. Joint and several liability assigns liability out of proportion to a defendant's degree of relative culpability. C. Joint and several liability compels solvent defendants to supply what insolvent or immune defendants do not contribute to an award of damages. Or D. Joint and several liability is imposed whether or not the plaintiff's fault contributed to the injury.
Since I don't know what some of those words mean, again, C.
Incorrect. The correct answer is D.
Good.